organizing this, and I especially want to make sure that I mention I'm a proud graduate of the Government Accountability Project. I spent a wonderful 5 years learning employment and whistleblower law, actually the case that I want to talk about is the case that Gab referred to me. It's by a gentleman named Jorge Vila, who's an international finance consultant. Don't ask me what he does. I've never been able to understand exactly what he does. Something about emerging markets and finding partnerships for World Bank financing operations. But what happened to Mr. Vila is that he had a contract, or several contracts, with the IIC, the Inter-American Investment Corporation, over a number of years. And they called him and asked him to do more work, which he did, and they subsequently refused to pay him for it. We filed a case in federal district court alleging a breach of contract, tortious interference with contract, defamation, and unjust enrichment. There's some case law, of course, or significant case law upholding immunities by the World Banks, and what it comes down to, from my understanding of it, having been involved in this, is that the banks do enjoy a significant amount of immunity under U.S. statutes as well as their own charters, but that they do waive some of that immunity. And the glimmer of hope in this case that I'm offering, hopefully, that we can expand upon, is that for transactions with outside entities, if the contract is involved in work that furthers the missions of the bank, they have waived their immunity for suits under those kinds of contracts. Clearly, the case law is that for employees, internal operations, they're immune from suit for that. But I think, as we all know, that there's a growing trend to outsource work, and I'm hoping that this little chink of light can expand. The court held that Mr. Vila's suit would go forward based on his unjust enrichment claim, that as an outside entity, the bank had waived its immunity from lawsuit for the work that he was doing with them, and it's on appeal now. I'm not sure exactly what they're going to argue. We haven't received the briefs about what they might argue is the basis for an appeal on this. But it seems pretty clear that at least for outside entities that work with the bank, the rationale is that they need to be able to do this in order to further their mission, and therefore they waive their immunity from suit. Essentially, they wouldn't be able to buy office supplies or do programmatic work with outside entities unless they did it on a cash basis, as long as they were immune. So they've waived their immunity in this area, and it's a growing area, I think, of interaction between the banks, or between the banks and the outside world. It remains to be seen what sort of issues might become possible to litigate on this basis. There are a lot of theories of wrongful termination for employees who are asked to do illegal acts. I'm not sure that would work in this context as an outside entity, but it certainly could be a layer of protection for consultants who, possibly for policy reasons, get suddenly terminated without any kind of explanation or cause. At the very least, it's a likelihood that they could file a breach of contract claim and make what happened to them public, which of course is a lot of what's necessary in these kinds of cases in order to bring attention to not only the individual plaintiff's problem, but the conduct that the bank is engaging in. I can talk about the case law in more detail, but I think that's the point that I'd like to bring to you and let you all know that if you are dealing with an outside contractor to the bank, they are not necessarily don't have the blanket immunity that in their own charters, and from the language that I've read, pretty much all of them have waived this kind of immunity in their own charters. So there is a glimmer of hope there that I hope we can expand on. Yes.
Steve, are you there?
Yeah, hi.
Steve?
Yeah.
Did you want to make a few comments about immunity and the banks?
I don't really have anything to add in the context of the employees or contractors, although I wouldn't disagree with anything that was said. But I've looked at the question more broadly in terms of people who might have tort claims, people who are adversely affected by projects, and trying to think through what claims might look like. And I think in general, the state of the law, at least in the United States, there is that the banks are pretty much immune from that. But I think that there are good arguments that could be put forward as to why the case law is wrong and how it could be brought to allow these some sorts of suits. So I've been doing some writing and thinking on that, and I'm happy to share it with anyone who's interested.
Okay, maybe if anyone's interested, contact me after the panel and I can put you in touch with Steve. Are there questions or comments?
Could you say who Steve is?
He is Steve Hurst, and he's a consultant with the Bank Information Center.
You know, I just wanted to step forward and thank you so much for coming, because you added so much to our session. I know around the world the problems truth tellers face are even greater than what we face at home. As Tom Devine was telling me, the first thing that usually happens to a whistleblower in another country is they're killed. And I mean, we have isolated incidents of that here too, like Karen Silverwood. Others of us have experienced, attempts in our lives. But there is routine. But I do have to say there's a commonality in what I'm hearing from you. Changes of administration. That's the perfect time to get rid of a whistleblower. You can predict when there's going to be retaliation. We did. When we knew that the chairman was going to change, we knew the day they were going to strike, just like Wolfowitz. And then he says, I don't know. This whole small, prove it. You need particularity. That's like rule guide B. And then I'm also reminded of that great film, The Third Man, by Graham Greene. Do you think about that? That people will kill babies for money. There's this great scene of a Ferris wheel, and who was it? Orson Welles looks down and says, see all those people, they just look like spots. Wouldn't you wipe them out for a little bit of money? They're just spots. And he was selling bad penicillin in the black market Vienna. I mean, these are problems that go all the way back to ancient history. But the other thing that this panel illustrates, that I just have to make this point on, we can't have meetings like this without GAP. GAP is the, premier whistleblower protection group. We need other groups. Each one of these groups has their own niche. GAP is great in protecting on a global retaliation. We also need lawyers. We need lawyers from TAF. We need civil rights protection groups. And what GAP has done beyond promote their own programs, which is form the Make It Safe Coalition. Now, whether you know it or not, each one of our groups is a member of the Make It Safe Coalition, all 42 major public interest groups. POGO, GAP, ACLU, Common Cause, Public Citizen. We cannot reinvent that. If we're going to have further meetings, and I think we all want to have further meetings, we must adopt the principle that all coalitions are equal and should have their host their own events and should be supported, and everyone has to have that freedom. No coalition reports to any other, but to coordinate it through the Make It Safe Coalition. We had a great week this week, and we expanded enormously from last year, the number of groups involved. But I think when we leave, I hope everyone goes back to the respective coalitions and say, we need to be united as never before. The kind of story we heard just now is the kind of story we've experienced here. You've probably experienced on a more massive scale. A lot of loss of human life. I'm a medical whistleblower. Human life. Absolutely. We have the doctors groups represented here. I'm a proud member of Semmelweis. We have Matthew Fogg here. We had a very good discussion about the need for unity as never before. And we've got to work through the Make It Safe Coalition, and we can do more. And let's just go back resounding that we're all going to work together through the structure of the Make It Safe Coalition. The IAW is going to cooperate with the Make It Safe Coalition any way we can. And there's a second coalition called the Liberty Coalition, which, again, 70 public interest groups. We don't have to reinvent the wheel. I just wanted to say your panel is an outstanding example of how unity throughout the whistleblowing community is essential. So, yes, I want you to. That's why I called Matthew Fogg in here, because I don't want any impression that we're not united as never before.
Just being a law enforcement whistleblower, and I think most people in this room understand the dictates of law enforcement and how important it is. Certainly working with United States attorneys, working with DAs all across the country. In our line of work, you know, we consider informants, and I'm sure everybody in this room knows when I say informants. I mean, it's very important that folks come forward and assist us in making our cases and being able to help others in this whole judicial process of making America safe. And one of the things that, as Jim was saying, what I learned is when you start talking about whistleblowers, you're talking about people who come forward. I mean, I think everybody in this room understands that, you know, you are under a certain amount of pressure to tell the truth. But I believe that as I took an oath, I swore to serve and protect this country. I saw it as heroic, as stepping up to the plate. And as Jim said, I mean, my life was placed in grave danger. I mean, whereas my actual backup walked off and left me on a stakeout to get killed. To God be the glory that didn't happen. But I tell everyone, I say, it's so important that we come together. We can be such a powerful entity. We really can. And then one of the things that Senator Grassley said yesterday, he said that he's going to try to, hopefully, that he can have it so that whistleblowers can come to the White House, Rose Garden, every year. To just because that's how important it is for us to understand this mechanism of what we call, I call it heroic Americans, the whistleblowers to come forward and tell their story. So I think it's so important that we've come together, and I'm glad to be a part of this Make It Safe Coalition.
Now, Sarah was just saying that maybe I stepped on answers, and we want more questions and answers. Now, to tell you the truth, I don't even know if we should restrict it to just this panel. Let's start with this panel, and I know we've got some questions and answers from this morning. Yes?
I just wanted to sort of bring together this panel and the last panel in response to something that Doug said having to do with the sovereign immunity issue, which is, I think, that one place that the panel this morning had to do with judicial accountability. And I agree with you because I think we work together on this immunity issue, but I think what is very possible is going to happen with regard to these sovereign organizations who have claimed partial immunity vis-a-vis their contractors is that they will be looking for arbitration clauses in their agreements with the contractors so that in the event that there is a dispute, there will be a private arbitration as opposed to judicial accountability under the legal system.
Yeah.
So I think that's just something people need to be aware of and look for, and I think there has been a growing trend in this country to substitute arbitration, particularly in the employment sector, for judicial oversight, and the courts, in fact, have taken a position that they would rather stay out of employment litigation cases. And I think that's a growing danger in a democracy.
I think it's incumbent on those of us that advise people who find themselves in that situation. Unfortunately, it has to be done beforehand in many cases. In this particular case that I worked on, because the court actually held the work that he was not paid for was outside the contract, the arbitration clause that was in his contract didn't apply. because his contract didn't apply, and the theory was an unjust enrichment theory. And that is where there's no contract, but I've done something for you, and you've been enriched by it, and I deserve to be paid for it. And so that is a particular danger, and it is in a way that the organizations are certain to try to avoid putting themselves in the place that they're in.
I suggest for next year we have a whole session on arbitration, because that is the outsourcing of our court system to private justice for the rich, and never, for whistleblower, never sign an arbitration clause no matter what.
Yeah, just, there was an incident a couple of years ago where a former World Bank employee in Bangladesh brought a lawsuit against the World Bank in Bangladeshi courts. And the courts decided to take up the case. The case was being heard. And then we heard that the Bangladeshi parliament was suggested that they actually look at the law that did not provide the blanket immunity to the World Bank and actually revise it. So there are instances where if there is progress made on challenging the immunity of the international financial institutions, they will try and then work with particular member governments to actually, tighten those types of loopholes in their mind. So those types of things might also start happening.
The other place you may just be interested in going to, and this is off the top of my head, and while the sovereign immunity isn't totally closed off in the U.S. because of the way the treaty was signed and the commerce provision, but with this growth with regard to arbitration, the one international body that deals with these issues is the International Labor Organization, the ILO, which has labor standards. I don't know what their perspective is on arbitration versus the judicial system, but with this growing, that may be someplace you want to look at. There are the 5 basic cores of labor rights that most countries have signed on to, not the United States. Collective bargaining. But you may want to take a look at that, what the ILO is doing or not doing.
I'm going to thank you again. I just got a note that we're going to need to start the next session, but I would like to invite that we have a more expanded session next year. What about International Day as part of the event? And I'd also like to say, let's have a big session on arbitration. And we just only scratched the surface here. Thank you so much for coming. Okay, as we're moving forward here, as people are rearranging, we're going